Getting a divorce in Arizona is actually simpler than you might think. One spouse must be a resident of Arizona for 90 days before a divorce can be filed. Once that is done, a legal grounds for divorce must be established. There is a 60-day waiting period before the divorce is finalized. In Arizona, there are two acceptable grounds for a divorce. These are no-fault divorce and general divorce. The sole no-fault reason in Arizona is irretrievable breakdown of the marriage. For general divorce, Arizona permits the following reasons for dissolving its covenant marriages: adultery, conviction of a felony which mandates imprisonment or death, abandonment for over 1 year, domestic violence against a spouse, child, or relative, living separately, continuously, and without reconciliation for over 2 years, living separately for over 1 year after getting a legal separation, habitual use of drugs or alcohol, and both spouses agree to a dissolution. Arizona does require a parenting plan for child custody, and neither parent is entitled to custody. Child custody is granted to either parent based on the best interests of the child. The court may consider the following: the child's preference, the desire and ability of each parent to allow an open, loving, and frequent relationship between the child and the other parent, the parent's wishes, the child's adjustment to his or her home, school, and community, the mental and physical health of the child and the parents, the relationship between the child, the parents, and any siblings, any evidence of significant spousal or child abuse, any coercion or duress in getting a custody agreement, and which parent or parents have provided primary care of the child. When determining joint custody, the court notes that neither parent was coerced or influenced by duress into withholding or granting his or her agreement to joint custody. The parents can sustain an ongoing commitment to the child, and that the joint custody agreement is logistically possible. Grandparents and great-grandparents may be awarded visitation rights. Either parent may pay child support regardless of misconduct based on the financial resources of the child's standard of living during the marriage, the child's physical and emotional needs, the financial resources and obligations of both parents, any destruction, concealment, fraudulent disposition, or excessive expenditure of jointly held property, the needs of the child, and the duration of parenting time and any related expenses. Child support payments are paid through the court unless agreed upon otherwise. Arizona Supreme Court has specific guidelines for child support payments available from the clerk of any superior court. The amount of support established will be the required amount of child support unless the court finds it inappropriate or unjust. Every child support order must assign one or both parents responsibility for providing medical insurance for the child and for payment of any medical expenses not covered by insurance. Unless there is contrary evidence in court, it will assume that the non-custodial parent is capable of full-time work at minimum wage, unless the parent is under 18 years old and attending high school. Arizona uses a community distribution property model. Separate property is retained by the owner of the property. Community property, property gained during the marriage, is divided and awarded as equally as possible, and marital misconduct is not considered. The court may consider excessive or abnormal use of community property and destruction, concealment, or fraud when making the division. The court may place a lien upon a spouse's separate property to secure payment of child support or spousal support as well. A notice of debts and creditors is provided by statute and must be included on any materials served to the respondent. In addition, either spouse may request that the court order the submission of a debt distribution plan, which assigns the responsibilities for any debts. Spousal support may be awarded if the spouse seeking maintenance lacks sufficient property to provide for his or her reasonable needs. Is unable to support himself or herself through appropriate employment. Is the custodian of a child whose age and condition is such that the custodian should not be required to seek employment outside the home. Lacks earning ability in the labor market to adequately support himself or herself. Contributed to the educational opportunities of the other spouse, or had a marriage of long duration and is of an age which may preclude the possibility of gaining employment adequate to support himself or herself. Marital misconduct is not a factor in determining spousal support, but the following do. Whether or not the spouse seeking support sacrificed to allow the supporting spouse to support the couple. The time for the spouse to acquire education and training for suitable employment. The spouse's future earning capacity. The spouse's standard of living during the marriage. The duration of the marriage. The ability of the spouse providing maintenance to meet his or her needs while providing the maintenance to the other. The financial resources of the spouse seeking maintenance, including marital property awarded and the spouse's ability to meet his or her needs independently. Any destruction, concealment, fraudulent disposition, or excessive expenditures of jointly held property. The comparative financial resources of the spouses, including their comparative earning capacities. The age of the spouses. The physical and emotional condition of the spouses. The usual occupations of the spouses during the marriage. The vocational skills of the spouses seeking maintenance. The ability of both parties to contribute to the future educational costs of any children, and any other factors the court may deem just and equitable. Alimony is paid through the court unless agreed upon otherwise. Support agreements may be non-modifiable by agreement of both spouses. Either spouse may ask the court to order mediation, to attempt reconciliation, or to obtain an amicable settlement and avoid further litigation. After a divorce has been filed, either spouse may request that the proceedings be transferred to the conciliation court for mediation. Official forms are available from the clerk of any superior court. If one spouse denies that the marriage is irretrievably broken, the court may delay the case for up to 60 days and order the spouses to a conciliation conference. Finally, there is a 60-day delay after serving the papers before any hearing may be held for a divorce. Visit us today at www.mydivorcepapers.com and click on Arizona at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.